welcome everyone to this webinar on business and human rights. Today we're going to talk specifically about the Binding Treaty on Business and Human Rights, and we're going to unpack it from the legal concepts, and we're going to have the treaty process elaborated as well from a feminist perspective. And with us, we're very happy to see that there's so many that has tuned into this call, and we're especially delighted to have our three panelists with us. First of all, Peter Muchlinski, that's Emeritus Professor of International Commercial Law at School of Oriental and African Studies, University of London. And Peter is an expert on multinational enterprises in the legal sphere, and is also a scholar that's able to unpack legal concepts to non-legally trained audience. So we're very happy to have you part. With us we also have María Suárez Franco. And María is a doctor in international public law, and she's also the permanent representative of FIAN International in Geneva. María is an expert on the right to food and nutrition. And thirdly, we're very happy to welcome with us Alejandra Scampini, that's a Uruguayan feminist and intersectional scholar. Alejandra is also the Senior Policy Associate at Poder and one of the co-founders of the network Feminists for a Binding Treaty, F4BT. So this webinar is a forum for capacity building. So the focus here is to unpack the treaty process, to understand it, how it plays out for human rights defenders and environmental defenders. And then to connect it to a feminist analysis jointly with all these legal concepts that we're going to look at. So my role here, I'm Sanna Ström, and I'm the spokesperson on human rights and business for FIAN Sweden. And my role here is to facilitate this process as smoothly as possible and to have us all on board and understand and unpack this treaty. We bear in mind that there's people on the call who have been engaged in the field for decades, and we also have people on the call who are relatively new to the questions. So we're going to have this as accessible as possible. On the organizations that arranged this webinar, it's Treaty Alliance Sweden, which comprises of Afrikagrupperna, FIAN Sweden, Friends of the Earth Sweden, Solidarity Sweden, Latin America-Grupperna. Also want to say especially welcome to the Deputy Minister of the Swedish Ministry of Foreign Affairs. We do have some MPs from the Swedish Parliament with us, and senior advisors, policy advisors at SIDA and various civil society organizations. Very welcome to you all. We do have my fellow on the technical side. I do have my fellow SOAS candidate, Victoria Dimitrova here, as well as Mauricio Contreras and Francisco Contreras to assist on the technical side. So this call is going to be 1 hour for the panelists to speak. And then we have 20 minutes of Q&A at the end, so you will see how that works.
So we're speaking about legal persons or legal person. That's individuals and or corporate entities are both legal person. An enterprise, it could be one corporation, it's one legal person or corporation. Multinational enterprises are several units of business relationships or legal persons joined together, but they're several. And that's what comprises separate legal personality, meaning that every separate unit has its own legal person. And that's also how they divide between themselves limited liability. So it's liability or responsibility or accountability, if you will, divided between shareholders and enterprises. That's how it started off, you could say. But these days, and since many years back, it's also divided between the parent company and the subsidiary. So with that very, very brief just mapping, I would like to hand over to Alejandra Scampini, that's going to talk a bit about, to set us off on the importance of the treaty process and perhaps a bit about why it's important in our current context of COVID as well. I give the virtual floor to you, Alejandra. Very welcome.
Thank you very much. My presentation today is basically from the experience of Poder, working as part of the Treaty Alliance from the early beginnings. We are part of the facilitation group, and also from the very early beginnings in 2016, when this, whole idea of a breakthrough in the international human rights framework with the binding treaty, we saw the need for a gender perspective. So we co-founded with Ana Maria and with many others, feminist well-known networks like AWID, like APLWD, Femnet, ActionAid, Womankind, Dawn, and WILF, and ESCRnet, members of ESCRnet, the Feminists for Binding Treaty, because we thought that we needed to make the case for how the binding treaty conversations and debates have to do with women's rights. So that's how I prepare my presentation for you today. I think we are in a very appropriate moment. Just a month ago, there was a panel in Europe convened by the Working Group on Business and Human Rights, also by Germany, where they launched a project to reboost the UN guiding principles, something that also in Sweden you are very much aware and supporting, together with other forms of mechanisms to have business accountable. And the aim of that panel was to build a plan towards 2030 with tangible results, to get tangible results for affected communities, and to renovate, also the commitment, and to renovate the sustainable development framing, given that the conjuncture today has proven that it's not enough what has been done. So in this space, in this panel, Poder was invited as civil society. There were many states, there were also multilateral agencies, private sectors. There were a lot of interventions celebrating how much we have advanced with these voluntary mechanisms. But in the context, as Sanna was saying, of this pandemic, that is an intersection of financial, economic crisis, due to many years of macroeconomic policies that have, increased inequalities and disparities among citizens, we have said that business cannot be as usual. We have to have an honest conversation about what worked and what didn't work and what is needed. So I guess this panel here and this capacity building is part of doing it better, right? And from learning with very fresh evidence. Yesterday in the Regional Forum on Business and Human Rights, Ecuador, Mexico, members of OECD, members of Inter-American bodies in Latin America, academia, reinforced this idea that indeed there has been advances, indeed there are new debates on due diligence, but these are not enough. And also they invited Latin American to really start creating more appetite, not only among Latin America, but also in Europe, to really invite them to build together a historic opportunity. Let me give you an example of how this is still, a big issue in the region and in the world. Especially tapping on one case, Poder has been working for almost 6 years. This is the 6th anniversary of the major toxic spill, Buenavista del Cobre mine contaminated the Sonora River in northern Mexico. The company responsible for what is, the worst environmental disaster in Mexico continues to enjoy impunity. So it's 6 years since the communities have demonstrated the consequences of how the acidified copper sulfate in the Bacanuchi and in the Sonora rivers have left more than 200,000 inhabitants indirectly, right? And 20,000 people without drinking water. Can you imagine living today in this confinement without drinking water? Well, this is still the case of the communities in Sonora. So in spite of all the legal advances, in spite of all the advocacy, in spite of even taking this to the court in Mexico, the court responded negative to these communities, and the abuses of the company, it still has not been resolved, even if they have promised to provide 20 million pesos Mexicanos in terms of water, providing improvement of the community. Only 1.3 have only been provided to the community. So this is just an example. And I also invite you to read the latest report of Oxfam that was launched, I think, some days ago. Pandemic profits for companies soar by billions, more as poorest pay the price. And in that report, you can see how many corporations, many have the base, the matrix in Europe, are cashing in the COVID, on behalf of the wealthiest. So even in this situation of health crisis, financial and economic crisis, the same elites, the same corporates are increasing their wealth. And 32 of the world's largest companies stand to see the profits jump by 109 billion more in 2020, as the COVID pandemic lays bare an economic model that delivers profit from the wealthiest. So this is what the Oxfam report says, and this is what we have been announcing for so many years, consultation after consultation. As part of the Feminists for Binding Treaty, we have been giving evidence on how the abuses of companies and the impunity or the corporate capture of the states are leaving women not heard, no access to justice, not recognized as victims. And so when the Binding Treaty started being debate in the debate in 2016, 2014, may I say, with the leadership of Ecuador and South Africa and many around the globe, this was an opportunity for the civil society, women human rights defenders, victims, to really make history and see their lives finally being repaired and remedied. So we celebrate the process, right? We celebrate this long process because in this long process, and I'm sure Ana Maria will talk more, we have learned how these abuses and violations are impacting certain groups, indigenous communities, women, migrants, women in rural areas, how the business economics activities all along the global value chain has different particularities.
Thank you very much. I think that sets us off in a very good way. So I will please allow Ana Maria to continue to speak a bit about how the binding treaty process came about and a little bit about the background to set us off further for the legal discussions.
I would like to share a presentation because that might be helpful for people. And this is just to let you know, first of all, that I thank a lot to all the organizers, also Sanna, who is the one who has been in contact with me. I think that it's very interesting to have this capacity building, having both the voices of the North with a professor like Professor Michelinski, so known because he is very good in explaining also non-legal terms, legal terms to non-legal people. So I think it's very helpful. This process is very technical. In many cases, people get lost in the technicality. So this is good, but also to complement with the voices of women from the South, women who have a different experience, who grew up in different countries where inequalities, injustice, and harm are present every day and everywhere. And I think that helps us to have a more international view than if we would just be looking from one of those perspectives. So thank you very much for this opening, and also thank you very much to Professor for being here and helping us to understand better. I wanted to let you know about how this process began. When I came to Geneva in 2011, this process was not there. And in 2013, when the guiding principles were adopted, many of the civil society organizations were not feeling well with the UN guiding principles, because some of them were feeling kind of instrumentalized, like they participated in all the process, and on the end what came out was more a document negotiated with the enterprises and the corporations, and not really attending to many of the demands of the civil society. And then people were like not comfortable. I remember I had to read the first statement saying what was critical or not really welcome from the principles, including the ambiguity, including that the obligations of states to regulate companies was more about an expectation, and especially the third pillar on access to victims being about grievance mechanisms based in the companies and not strengthening justice. And we were on that time very concerned because all the extraterritorial, the transnational dimension was missing. So I remember that we were very, very clear in saying, look, we have a transnational problem which is created by transnational webs of companies, but the guiding principles try to solve that from a national perspective. So we have the limitations of the national law in tackling a transnational aspect, and therefore still many gaps are there. And therefore, on that time in 2013, we had a very first a statement of civil society organizations in Latin America in the regional Forum on Businesses and Human Rights in August in Medellin, Colombia. Then some days later in Bangkok, in the forum, in a people's forum, we got the support of more than 400 organizations, which asked for the Human Rights Council to advance in the negotiation of a legally binding instrument. This group of 400 grew up, and then around 1,400 were asking the council to initiate the process. And this was a huge sign from civil society, especially from civil society affected or being very close to affected communities by harm caused by companies, and especially transnational companies. So on that time, we were discussing about which was the aim of this process, and we said that we would like to have an international treaty because it would be important to have a level playing field and not to rely in national laws that have, or national policies that have very different ways to tackle with the issue. A minimum would be needed, not just for the affected communities, but also for corporations to have more legal security. And especially for us was important to ensure that there are mechanisms to hold the TNCs and other business enterprises liable, recognizing that TNCs should have the obligation to respect, prevent, and repair, very different to the state's obligations, which are respect, protect, and fulfill, right? That should include that the state should impose these obligations, not just in their territory, but also along the value chain, and also in the corporation structures that are transnational, of course, respecting the sovereignty of states. And those especially to close gaps in international law and to balance the regulatory asymmetries where companies, for example, in trade law, have many advantages and rights, while the people are quite unprotected still. So Of course, improving access to justice for affected communities was other of the goals, especially in this extraterritorial or transnational context, including also to ensure that judges in different states can cooperate and can have mutual assistance. In many cases, you got a decision in favor of the affected communities in the country where the victims are, but it was impossible to enforce the decision because the money, the assets, was somewhere else. And then we said, okay, but what is happening? And we found many barriers, as for example, the use of what is called the forum non-convenience, but also the fact that companies, when they saw these decisions coming, disappeared from the country or moved the assets to other countries, made the implementation of the decisions very difficult. And then we said, okay, judges will have to cooperate better, and this has to be established internationally, because just one national law cannot establish necessarily. You will always need some kind of agreements with between the involved parties. And of course, the idea was also that we can ensure that there is legal liability in the criminal law, in the administrative law, and in civil law, which have very different goals, and maybe Professor Michelinski will go into that later. So which actors do we have in this process? We have states. Of course, this is an intergovernmental negotiation, and for us it is very important. Different to the guiding principles, states do not negotiate with the perpetrators. We want states to represent us democratically and to take decisions looking into the public good and not to be representatives of private interests. So one of the biggest demands of civil society was to protect this space from undue interference by governments or even corporate capture. The civil society, which has many different groups, but let's say our kind of parliament is the Treaty Alliance, where we have a diversity of views on how business and human rights law has to evolve. But we also have other groups which have kind of different views, like the Global Campaign to Dismantle Corporate Power, the ESCRnet, or even regional organizations as the African Coalition for Corporate Accountability. In any case, even if we have plurality of views, it's interesting to see that the movement has got closer in many points, as for example, the concern about the corporate capture, and as for example, the concern about the feminist demands, which are common to all. This is very great. And then the corporate sector is participating, even if we ask for them to stay aside, but the International Organization of Employers, the International Chamber of Commerce, and others are participating as observers in the negotiations, many of them also influencing their national governments, which is quite uncomfortable for us, because in many cases, the asymmetries of power in the spaces that we have to share with them make that to bring our points is not easy.
Thank you very much, yeah. Anna Maria. I think that will continue our discussion further in a very good way, to hear how the process came about and a bit about the controversies as we stand now. So I will ask you to take over the floor, Professor Michelinski, to also share some views on the technical legal sides and unpack it in a way, what legal concepts are behind the binding treaty and how we can understand them now as they've developed.
Well, thank you very much, and thank you for inviting me. As a disabled person, it's very difficult for me to travel, so I've benefited from the pandemic because I can actually take part from home from my sofa. So thank you again, because it really is a wonderful thing to be able to share my ideas. Now, I've distributed a backgrounder to accompany my presentation, largely because I needed a roadmap around the second draft, and I hope the participants will find that useful for their own purposes as well. But in discussions with Sanna, we've thought that 3 issues should be highlighted by me. First of all, the question of international binding obligations on private corporate actors as a general question. Then secondly, the specifics, particularly of Article 8 on liability in the context of group structures and subcontractor relations in global supply chains. And the third element is the relationship between different levels of international norms, particularly between human rights norms and trade and investment norms. And I think that will probably take me to my 20-minute limit very quickly. So let me get on. First of all, one of the main arguments in favor of having a binding treaty is that it will offer a forum for the clear articulation of internationally binding obligations under international law for private actors. And in that sense, it circumvents the traditional objection to such developments, namely that private actors are not persons in international law and therefore can't hold obligations. But it is a well understood fact that international obligations are possible for private actors within a treaty context. Also, we have a number of lacunae in the regime of making corporations accountable, which Anna Maria has already touched upon, and a binding treaty would be able to establish some kind of core of legal obligations, which balances out also the legal rights that corporations have, particularly under trade and investment agreements. And finally, there's the advantage potentially of resolving some of the technical problems that are inherent in litigation to hold multinationals accountable, particularly jurisdictional problems, lack of remedy, and the capacity of corporate actors to insulate themselves from liability through their legal structures. Now, I haven't got time, I think, to go into jurisdictional issues as such. I'd be happy to answer questions, but I will focus, first of all, on the question of corporate liability. Now, Article 8 is the key article here, and in line with the UN guiding principles, we have both direct liability for violations and indirect liability for the human rights abuses of business partners. Now, the conditions for indirect liability are stated in Article 8.7 as firstly, failure to prevent another legal or natural person with whom a business has a relationship from causing or contributing to human rights abuses where the former controls the latter or supervises the latter. So we have, first of all, a control test. And then secondly, there is a foreseeability test, because the provision goes on to say, should the first business have foreseen risks of human rights abuses in the conduct of their business activities, including activities of a transnational nature with business relations, but failed to put adequate measures to prevent abuse. Now, as an English trained lawyer, I read that as a sort of implicit duty of care based on foreseeability and lack of reasonable precautions being taken to avoid harm. But the wording here is quite ambiguous. It may be that this is a result of a compromise between civilian and common lawyers. I'm not sure. The other thing to point out is that business relationships here mean all sorts of things which are legally quite distinct. And I think it's important to bear in mind a basic distinction between owned and controlled subsidiaries in a group and contractual relations with subcontractors in production chains, because the two things raise quite distinctive legal issues. But the question I want to raise for discussion is, does Article 8 go far enough? Now, the control test that is used is a common method for establishing liability, but proving control is extremely difficult, and not least because victims don't have access to the evidence which the corporate respondent will have as to their precise legal organization. And then there's the question of interpretation. What does this all mean? And I mean, it's quite easy actually for a parent company to say, well, we don't actually control the day-to-day activities of our subsidiary because we just give general guidance. And these sorts of arguments have actually found favor in the English courts. In the Thompson case, which looked again at Chandler and Cape Industries, which is a very famous case about establishing parent liability for the health and safety activities of its subsidiary. Now, should a third draft include certain other things, for example, a presumption of parent company liability? Now, that would be problematic from probably a policy point of view, because an awful lot of countries don't accept a presumption of parent company liability in corporate law theory or practice, and whether they'd be willing to introduce that via an international treaty is a big question. It also represents, incidentally, an attack on the doctrine of privity of contract, where the controlling enterprise may have no direct relationship with a subcontractor further down the chain. And as was pointed out, I think, earlier by Anna Maria, that you may have a remote chain and it's the subcontractor who's really breaching human rights. But the parent company could then, or the lead company in the production chain could quite easily say, well, we haven't got control over this, and therefore why should we be liable? The second thing is possibly introducing an express veil lifting provision. But the problem I find with that is that most veil lifting laws are very restricted in their scope. We'd need really a justification for lifting the corporate veil based on a general principle of furthering substantive justice for victims. And I don't know of any legal system that does that these days. American law came close to this many years ago, but even the American law has kind of wound back a bit. And certainly the English standard is only if the corporate separation is being used as a vehicle for fraud, would the veil be lifted. So veil lifting is actually very limited in its scope, I think. A third option is strict liability for the parent. Now, in some of my writings, I've actually suggested, well, look, we could go down a sort of strict enterprise liability route. The Indian courts have done this in response to the Bhopal case, for example. But again, it doesn't take care of the problem of control and of the group structure and the evidence needed for this. And that brings me to another question. What about burdens of proof? Mm-hmm. Shifting the burden of proof from the victim to the respondent could take some of the pressure off, and it would work like this. The victim needs to prove the violation of their human rights. And then the presumption arises, well, the parent must have been responsible for that violation at the hands of the subsidiary. And then the burden can shift so that the parent can disprove responsibility. But I wonder whether this actually helps us very much, because the prima facie evidence that would be needed is already quite high. And we see this, for example, in jurisdiction cases where substantive liability isn't yet an issue, but yet we have very detailed and in-depth debates about the corporate structure and management relations between the parent and the subsidiary. So I'm not sure about that. Finally, joint and several liability. Now, joint and several liability underlies the logic of many of the cases that have been brought in the English courts, where the allegation is that the parent and the subsidiary were joint tortfeasors. And this principle of joint and several liability avoids a lot of the problems of corporate separation. It has nothing to do with veil lifting, because two independently legally structured entities may take part in the same stream of events that causes liability, and they may have joint responsibility for that. Now, this is a principle that has been recognized in most legal systems, and it may well be that some kind of argument for joint and several liability and clarifying Article 8.7 as meaning that this is what's at stake may be helpful. Now, on to my second substantive point, because time is running short. I'd like to talk a bit about the relationship between human rights norms and norms found in other international agreements. Now, I do business and human rights, but I'm mostly known for my work on international investment law. And I spent many years at UNCTAD helping out with ways in which we could negotiate possibly slightly fairer BITs, or bilateral investment treaties. And in that time, I've realized that there is a real tension between the needs to make corporations responsible for their actions and the privileges that they already enjoy in trade and particularly investment agreements. Now, Article 14.5 of the second draft of the binding treaty tries to get around this. It does two things. First of all, it looks at existing agreements and exhorts the parties to interpret them consistently with the Business and Human Rights Treaty. And for new agreements, the exhortation is that it should, if I can read it out, that any new bilateral or multilateral trade and investment agreements shall be compatible with the states parties' obligations under this instrument and its protocols, as well as other relevant human rights conventions and instruments. Now, the question I have is whether this provision should go further and actually add a clear statement to the effect that international human rights law takes absolute precedence over trade and investment treaties. Now, this is a position advocated by some participants in the debates, but it raises, again, another technical legal problem. What if a party to a trade or investment agreement is a signatory of the Business and Human Rights Treaty, but the other party isn't? Are we saying that the Business and Human Rights Treaty has a wide-ranging normative force that actually it imports itself into trade and investment agreements, whether they have express provisions on this or not? Now, one way around this might be to actually suggest that the signatory states demand a human rights protocol of their counterparties in trade and investment agreements. And there is some movement already in new generation trade agreements to have at least hortatory provisions about human rights obligations and corporate social responsibility. But one thing that this treaty could do is perhaps actually produce a model of a human rights protocol. And such a human rights protocol is not unprecedented. For example, the Baku-Ceyhan the Baku to Tbilisi-Ceyhan oil pipeline and concession agreement has such a model. So I think these are the sorts of questions that might actually be quite helpful towards furthering the goals of some kind of harmonized legal accountability. But as I say in the last part of my background, I remain worried about whether the main home countries are going to buy all of this. And without the home countries on board, the Business and Human Rights Treaty is going to be problematic in its application. And therefore, it might be sensible that we go on a slightly less ambitious route. But I'm open to this. I'm not involved in the negotiations, partly because physically I can't get there. And I'm not quite sure what the mood music is back there. I mean, my sympathies are that we need to have a properly harmonized transnational system of national remedies, and that the problems of transnational litigation that arise from national remedy approaches need to have some kind of transnational harmonization, in the same way as we do it for things like service of process abroad, gathering of evidence abroad. Why not actually deal with the procedural problems of transnational litigation through an international treaty? That doesn't seem too much to ask. I think that's probably all I should say for now, because I think I'm about a minute off my maximum. So I shall await questions, and thank you, Sanna, and the organisers once again for giving me this platform. Thank you very much.
Thank you very much. And then, as in the name of capacity building and my own curious mind, maybe, since we have a few minutes, I would like to to have you expand on what like having duty of care coming from the tort law. What does it mean that you bring it into human rights due diligence, and what's the difference?
Yeah, well,
and then perhaps if you could, or secondly, sorry, if you could explain what does V-lifting mean, and how in what sense is it limited? Yeah.
Well, on the first question, how tort law can guide human rights claims. Way back in 2012, I published an article in the Business Ethics Quarterly about how we can convert the UNGP's due diligence standard into a legally binding duty of care. And I think that I have a reference to that article in my background, by the way, and I think similar arguments could be made about a reference to due diligence-based liability in Article 8, because as I said, the second pillar of Article 8.7, it already mentions foreseeability of risk. The second element in the tort law is the existence of a duty of care because of the foreseeability of harm and risk to the victim. And then the next step is to prove failure to take reasonable measures to protect against harm. And finally, that failure caused the harm. So those are the four elements of the English tort of personal injury, which is the way that English lawyers have actually structured claims against corporate defendants. But then they come across the problem of legal separation and responsibility and joint and several liability, which brings me neatly onto the veil lifting question. I think there are two things we have to keep separate here, which may not be entirely clear to non-lawyers. And I don't blame people for that, because it seems so obvious that if you have a parent and a subsidiary, they're managed together, they are the same thing. And yet in legal terms, we can legally separate the parent and the subsidiary and then claim that they're strangers to one another. In fact, in law, multinational corporate groups don't exist. All we have is a multiplicity of holding foreign shareholdings in local companies. And so we have to get outside the legal definition and see the reality, the enterprise that underlies the legal form. And then that raises the question of, should we not actually align legal responsibility with enterprise reality? And this is where we're getting all these problems, because corporations like being able to separate their liabilities out into different parcels. Legal separation is very useful, not just for avoiding personal injuries claims, but it's useful for things like tax planning. It's useful for protecting intellectual property rights and so on. So there are quite a lot of quite valuable commercial reasons for having corporate separation. But is it a valid commercial reason to then expect corporate form to protect against group liability when it's the group that's actually caused the harm? And the other problem is this, that even if the parent company hasn't had day-to-day control over the subsidiary, it has funds. You know, if you have a major environmental disaster, for instance, the subsidiary will not have the capitalization to pay all the damages. That's why you go for the parent. But the law tries to insulate parents from all of this. Now, limited liability is a different thing from corporate separation, very quickly. Limited liability simply says that a shareholder in a company has liability up to the limits of their shareholding. So it's not as if they have no liability, but they can limit their liability to the value of their shareholding. Now, the two things mesh together, though, with corporate separation as well. And as a result, parent companies can avoid liability, even if they own 100% of the shares in the subsidiary. Because if the share is only worth £1 each, that's the limit of their liability, £100. So these are the kind of legal problems that, as Philip Bloomberg rightly says in his magisterial works on corporate groups, which were never foreseen by the people that developed the corporate legal form, but they've been morphed into this kind of network of legal irresponsibility by the realities of corporate group structures.
I think we should round off with that one. Thank you very much for explaining further. So I would like to invite Anna Maria if there's any specific comments on the treaty or any specific legal concepts that you think should feed in more to this explanation or mapping, if you will, of what we need to have with us to understand the binding treaty.
Yeah, thank you very much, Sanna, and also thank you, Professor Michelinski. As it's very refreshing to hear a voice that is not in the negotiations and a legal voice. My voice is from the negotiations, and also since I am a human rights defender, of course, it has a side. Let's say it's not the side of the theory and the legal coherence, but it's the side of protecting the victims, which is also in your discourse, but maybe from a different experience. And I would like to highlight to the participants some elements. In some of them, I will answer or put questions to Professor Michelinski. I think that it's important to clarify that since the first, the zero draft that we had 3 sessions ago, and until now, the draft is improving. It's not perfect because, as Professor said, this has many compromises because this is the outcome of a political negotiation. So here you have the big challenge to do political negotiation, trying to bring legal clarity, and that's not always very easy. So it has 2 effects. The first is that we have elements inside that are very important for what civil society wanted to have on the beginning, but still this diplomatic language makes that some of the provisions are not clear enough. And a bit the fear that we have is that then when it comes to a judge that has not related in any way to the process, this judge could have a very restrictive restrictive interpretation, and therefore I think they clear the language is the best we will have this process, this treaty, this legally binding instrument applied. I also would like to say that it's important to clarify that the current draft already complements the UNGPs, even taking elements that are in other standards that have been developed by treaty bodies, like the General Comment 24 of the Committee on Economic, Social and Cultural Rights. So like the treaty is the next logical step in the evolving character of international law, knowing that our states, when they represent us in lawmaking, answer to the different challenges that appear in societies. And I think the COVID has put many of these challenges in evidence, like, for example, what is happening now on all the discussions on vaccines, if companies will abuse, for example, of the property rights they have over the vaccines, etc. So it's an example on how the evolution of the society also requires the evolution of the law, and we are on the right way. And I really like what Professor Michelinski said on the importance to align the legal structures with the economic reality. I think that's part of what we would like to have here, but it has not been very easy due to the resistance of some of the states. Yeah. Because, of course, we know that when civil law appeared and when the idea of the legal person appeared, it was to avoid liability, and it was to avoid that the shareholders would be responsible to the outside. So it was law done by the powerful, and what we do with human rights is to try to have law that protects the weakest in the society. And of course, this represents a political tension that makes that negotiating this kind of treaty is not an easy job. Furthermore, I would like to call your attention on some topics that could be interesting. This new draft replaced the definition of businesses' activities, which were before based on contractual relationships, and now the term is businesses relationship, I think this is very positive, because one of the problems improving the relationship between the different units of an economic group or a value chain is that not everything is contractual. So it helps a lot. Nonetheless, some of the people criticizing said, okay, but no mention of value chain is inside. I think a good legal analyst, as Professor said, would say, okay, these relationships include both the value chain and the economic groups, but it might be helpful for more clarity to say, for example, businesses relationship, including those within the economic group or the value chain. Another aspect that might be not very easy during the negotiations is that the original mandate is to regulate transnational companies. And if you go into the current text, this is covering all businesses, and it's mainly answering to the demands of the European Union and in general, the industrialized countries. I think that might pose some questions from the countries in the South, but I think we have to try how to solve this. And I think even if along the whole treaty, the TNCs are mentioned, maybe in the purpose of the treaty, a provision could be included stating that the purpose is also to close the gaps regarding transnational companies, the regulatory gaps that might help to bring the different parts in this political tension together. I think the 3 articles on access to justice and protection of the affected communities, which in the classical legal terms are called victims, but victims don't like to be called victims in many countries. We have some elements that are very interesting, like the class actions, because in many cases, like for example, the Brumadinho case in Brazil, you know, where this big water dam exploded and all these communities were affected, to have just individual claims is not helpful. You need to have a collective claim, and this is an advance. I think that also the fact that companies are conglomerates and the communities, to divide the communities would increase the power relationship. So allowing people to claim together, especially when they have a common interest, is very important. The gender perspective, Alejandra will speak about it. And all the elements about legal assistance or not having costs that impede access to justice or put an extreme burden at the end of the process are very useful, same as the protection of human rights defenders. Nonetheless, some things will have to be improved in this aspect, and I think including rural communities and peasants as vulnerable group is important, because in many cases the most affected have been those rural communities, like for example in all the water pollution or in mining activities. I think a bit answering to the difficulties improving the control, a stronger clause on information is needed, and maybe that's the place where the rebutable presumption of control could go, like to say, okay, if all information needed to show how are the relationships within the group or the value chain is not available to the affected, then the rebutable presumption of control should operate, and that would connect directly with the liability clauses in Article 8. And I understand that Professor says that the burden of proof is not always helpful or cannot be strong enough. In any case, we think that it would be important, especially because it helps to the equality of arms in the legal process, and in this sense, it shouldn't not be led to the national rule of law, but already be a standard in the treaty to be stronger.
A bit of these questions can then come back during the Q&A. And also in questions from the attendees, but I want to also give the space to the gender analysis and Alejandra.
Thank you very much. I think that this is a very useful conversation, especially because, as the doctor was explaining, you know, or asking actually, you know, what is the music? What is the music in the background? You know, I'm not a lawyer. I have to say that I think at this time it's a combination of political and technical work that needs to be done. So these kind of conversations where we can go into the nitty-gritty of, you know, how this language, as it is right now in the second draft, can actually, you know, be read and leave no room for, you know, different interpretations is key. So thank you very much for your knowledge. It has been almost, maybe Ana Maria, you can tell me wrong, but 3 years of educational processes trying to elaborate. And in that process, the Feminists for the Binding Treaty, what we did was to provide a lot of analysis on why we need to make a case, right, for the feminist angle. And I have to say that the very first zero draft was actually totally neutral, zero mentioning on the particularities of how women can be affected disproportionately or differently, you know, to men. And also because feminists not only look at this issue of adding women and stir, right? Having a feminist perspective into the binding treaty is also looking at the structural issues. So everything that Ana Maria said is also part of the feminist angle, is also part of, you know, moving, changing the way things are done, breaking with the asymmetries of power, trying to also break with a model that put women in the situation, you know, of disadvantage. So when thinking of a feminist perspective, you have to also bring all the knowledge that your state has in terms of all the long history of agreements on women's rights. I mean, when talking about this instrument, is also looking at what have you agreed in terms of women's rights, sexual health and reproductive rights, workers' rights, migrants' rights, indigenous women's rights, education rights, myriad of rights that you have signed, that you have been so powerfully aligning, you know, with feminist movements. Take the case of Beijing, of Cairo, of CEDAW, that is a convention that fortunately now is included in this preamble, is part of the background that we need to have. This is not just about trade and investment. This is not just about, you know, profits and companies and whether, you know, it's a parent company that has no connection, you know, with a subsidiary. This is about lives. This is about sustainability of life. And fortunately, we are not departing from zero. And there is an accumulation. You have vast advances on workers' rights in your country. So it would be, and many countries in the European Union have a lot of advances in terms of women's rights. So it would be important that you also take the lead in this process and see it from that angle. From our feminist analysis, when we look at this new draft, we say, okay, it's not bad, but it's not enough. As we said, and I know in Europe you are having a conversation about due diligence laws, and you have to know that whatever happens in your region impacts in other regions. So it's not about, as yesterday we heard, you know, go in due diligence or go in the treaty. This is complementary. And complementary means that no one can be lower than the other. So as you enter in your dialogues about due diligence, you have our recommendation is that you integrate international standards in terms of human rights. And also in those due diligence conversations, you have to think about extraterritorial obligations and justice mechanisms, mitigation and reparation for the communities that are outside the European Union. And also, and this is a claim that we still see in this process and elsewhere, is how we are still at the margins of the conversations. This is still about, as they say, technical. This is too technical. The panels are full of men. So we need to really see more women at the front, the ones that are really bearing the consequences of the abuses. There is a little advancement in this text. There is now official reference to human rights defenders, but we still need to know how the declaration that is mentioned in the preamble can really be a mechanism to really strengthen the voices and the access to justice to them. And also how, think about a stronger participation in this process. So far, the silence from some European countries, or this question of not still be clear about the role, is really trapping the advancement of a more quality conversation and frank conversation. Yes, there are doubts. Yes, there are things that need to be clarified, but this is a question of life, of sustainability of life, and stopping corporate impunity. Reading any report of today's situation of COVID tells you, that things are very difficult to be built back better, as the UN says, if we don't change some rules of the game. And in that game, women and the perspective analysis, we have accumulated a lot of analysis. This second draft is better in including women. We think that the fact that there is inclusion of gender-sensitive assessment, gender-sensitive analysis, it's correct, but still not enough, because having a gender perspective also means looking at other groups, at how, women, indigenous, women in rural communities, they are very peasant communities, peasant women are really not looked enough. We have been struggling to have a separate conversation on this, right? Women are part of the big shopping list of other situations, and it's critical how we really, hold conversations that can look at the specificities. As Ana María was saying, no one is gonna say no to gender issues. Well, bear with me, I have some doubts, there are moments in which gender cannot be, used as a merchandise. It's really looking at the structural issues. So yes, we are happy with certain advancement. This has been especially thanks to the Feminists for Binding Treaty, many allies in some delegations that have a history of, supporting women's rights in other processes in Europe, for example. But adding women or gender doesn't mean that is enough. We need structural changes. I'm not going to repeat what Ana María was saying. And we need, I think, to have more opportunities to this kind of dialogue. I think, FIAN, you are doing this awesome, because this is the kind of conversation that needs to lead to the consultation in October. We are not hearing how exactly is going to be the position of some groups. These groups need to really take the lead and in autonomy of the companies, knowing that there is an economic crisis, but also knowing that sustainability of life is at the center. And I'm sure that when you think about building back better, doing things differently, will be not at the cost of human rights. So think of the binding treaty not as either or, but as part and complementation transnationally of your conversations in your region.
Thank you very much, Alejandra. I think that summarizes super well for us to step out of the technicalities as well, and to have those two thoughts in mind of the technical issues that needs to be pinned down, but especially that it's also a matter of human life and secure human life and dignity. So I think that is it's very key to have those two thoughts in the picture as we go further, and look forward to the negotiations upcoming. So I believe now it's time to look at the Q&A, and the first question we have here is, we believe, directed to Professor Michelinski, so we'll allow for that one. And then we do have Ana María that wanted to comment a bit on implementation. And if there's any other questions from the attendees, please do type them in. They don't have to be clearly or complete formulated thoughts. You can try something that came to your mind during this conversation. So feel very free to just bring out what you think about. It's fine. We're here to learn, everyone, all of us. So is it safe for me then to have you answer this first question, Professor Michelinski?
Has everybody read the question? That's the first point.
Yeah, I was going to ask you if you might be in a better position to summarize it as well, or
yeah. Well, the question is from Barry Patel, or sorry, Bharti Patel. Sorry about that. The current discourse is largely silent on the remedy to victims of gross human rights breaches because of the generality of the third pillar in the UN guiding principles. And then the questioner goes on to say that the UK Transparency and Supply Chain Responsibility in the Modern Slavery Act doesn't really deal with questions of what companies should do, for example, corrective actions if they find cases of exploitation and modern slavery, or indeed their liabilities. Well, I think the answer, it goes back to the kind of technical legal barriers to responsibility that I mentioned earlier. And for all the worthy value of having strong reporting responsibilities in a statute like the Modern Slavery Act, or if we had, say, a reporting responsibility in the final version of the binding treaty, what it does is it kind of deflects attention from liability in the sense that you have a report you can read, and reading reports doesn't actually get victims remedies. What does get victims remedies is legal creativity in manipulating the limitations of the existing legal order, which, let us not forget, has grown to protect private property rights in a capitalist society, somewhat to give way, and that is the key. Now, the government, certainly not the British government, it's not going to suggest ways of making corporate life harder. And it's for a civil society to continue to articulate ways in which this is wrong and how technically it can be improved. You see, to follow Alejandra's point about the feminist perspective, what I pick up from that is that a feminist perspective, which is a different perspective on how life should be lived, let's not forget. It's not just about making women equal to men. It's an ideology of liberation, but it's an ideology of liberation that then gives depth and substance to human rights claims by pointing out, for example, that women and girls may be disproportionately affected by corporate abuses of human rights. But that perspective doesn't give us answers to how to deal with the limitations of capitalist law unless it starts by subverting that very notion of law. But that goes way beyond what we could discuss in a treaty negotiating forum, and we're all aware of that. So I think the two things have to go hand in hand, that we have to have a wider perspective on what we're trying to remediate, what are the main tasks of improving the relations between businesses and potential victims, and then making sure that the tools are there to make things happen if things go wrong, because that's what we're really talking about. In a way, John Ruggie was right to say what we need to do is change corporate culture. And one way in which we change corporate culture is not within law as such, but through changes in the perception of risk. And for example, a feminist narrative can make male managers perhaps more sensitive to what they're doing. But then the lawyer has to come in and say, if things go badly wrong and there's a need for compensation, what technically can we do to make that happen? And that was really the thrust of my presentation earlier. But it's such a difficult mountain to climb. And may I add, you know, as Alejandra was saying, that a great deal has happened, and Ana María has also been saying, a great deal has happened. I'm old enough to remember a world where nobody ever talked about human rights responsibilities for business. Back in the 1970s, this would have been laughed out of court. But now, 40 years on, we're talking about an international treaty. Well, if that isn't progress, I really don't know what is. So let's keep banging on.
It's very interesting to hear these political reflections behind, and on the same time, the very fine analysis of Professor Michelinski. So thank you for the space. And I am provoked. So before saying something on implementation, I would like to say that this relates to a feminist approach, because what we want is also, as he said, a liberation, right? And part of the liberation or the anti-colonial thinking is about not always making responsible the very small companies at the end of the value chain, but ensuring that those which are getting the big profit and have the economic power are also liable. And it's part of the same, right? Why should the women take all the care, and why cannot all the members in the family be responsible, for example? So it has the same logic. And I think, of course, a treaty does not change a culture, but you cannot just use carrots. You need also sticks. And I think this is the stick to the liability, right? And I think all what Professor Michelinski said about how to avoid the limitation of liability is key in this treaty, so that we ensure that we do not just have the carrots that we have in many instruments now, but that we also have the sticks. I just wanted to call the attention on one additional thing. We have on implementation, we have very different challenges. One is the one of ratification, but on that, we feel that it can move because many countries are beginning to work on the national due diligence laws. Hopefully it goes beyond just due diligence and also takes the broader duty of care, or what we call the theory of damage in the continental law, at least in Latin America. But the other problem we have, and this is even bigger, is the corporate capture or corporate interference. One of our fears is that the treaty relies on parliaments doing laws to regulate companies. But what happens where these parliaments are extremely influenced by the corporate power that has to be regulated? How do you avoid that these laws are bad laws? Let's say they are deficient in the legal content. And in this sense, we have to be creative, as he said. Of course, we cannot change this from one day to the other. But for example, in the Latin American constitutional law, judges have the possibility to directly apply obligations in international treaties to what we call the constitutional block, when parliaments, for example, omit their obligation to legislate, or are taking laws that are contrary to the constitution. So I think this is a good exit to this problem. It's not having direct obligations in the treaty that would weaken the state. It recognizes that the state exists and is the main responsible. But if the parliaments are not doing their work, then the judges could correct it. Other problem is when judges are also corrupted. So it continues, but at least having this idea of exceptions in which the treaty could be applied directly on the obligations of companies could be interesting. It's easy in countries with a monist system, very difficult in those with a dualist system, and there we need to reflect more. And of course, just to finish, for implementation, this new draft is missing the individual complaint that it had two negotiations before, or an inquiry procedure that could be in the hands of the treaty body. Many organizations ask for an international court. Some people criticize, saying international courts are not always available and cannot cover all the cases, and it would fragment. But some academics say, why not to pave the way for extending the jurisdiction of the International Criminal Court to corporate abuses. Now it's just for natural persons. It could cover corporate abuses, and I think that could be an interesting solution. Thank you very much.
Thank you, Ana Maria. And then I would like to hand back to Alejandra for some comments on the gender perspectives being discussed, and also on to comment on the new draft from a feminist perspective.
So yeah, it's very motivating. Only yesterday we were at and still today we are at the Forum on Business and Human Rights. There was a very also interesting conversation on the binding treaty, and Maria was there, Carlos Lopez also from Juristas Internacionales, and it seems to me that we are still in this process of educating ourselves about, how, the language can, these new realities, these new laws that we need to create can really encompass what is going on, the impunity that is going on, the profits of the companies that is going on. And yes, we have advanced, but we need to really see, the will from states to really make sure that this binding treaty is really robust, and part of that culture that we need to change, right? And from the feminist angle, since early stages, our recommendations on content, I have to say, still persist. There's still a lot that we need to reinforce in terms of mandatory gender impact assessments. As you know, at national levels, this is not the case. When we talk about assessment is, human rights or environmental, but not gender, there is no data collection. So to make it explicit in this binding treaty and how, and how important it is to have it not just mentioned in a preamble, but all through, it's very important. Also, the request for gender sensitive justice and remedy mechanisms. If for any individual it's difficult to access justice, more for women who have, a lot of structural barriers to really denounce, to really come out, to really participate in civil society mobilizations, campaigns. When, for example, in Sonora, we attend these meetings, we try more and more and to have women engaged, but most of them still remain at home. It's men that speak on behalf of, communities, but the particularities of how women, are the ones that then bear all the burden of, care, like now in COVID time, doing all the water provision, education provision, even in a context of abuse, environmental abuse, corporate abuse. These things need to be really taken into consideration. And I think that with the COVID crisis, there are more ears to really listen to what we mean by gender perspective, especially in the access to justice and remedy mechanisms. We think that in situations of conflict, this is still a big debt. We cannot have a one treaty for all. We need to really see how mechanisms are really looking at different particular contexts, like in conflict situations. Respect and protection and enabling the participation of women human rights defenders. As you know, in my region in Latin America, women human rights defenders, especially the ones that are denouncing corruption, environmentalists, are the ones that are at the front. And the highest killings of this persecution and killings of activists it's stopped in the world. Recently, the figures in Colombia are atrocious, how they are, really against paramilitares, sometimes the state, sometimes corporates, hiring army forces to go against the human rights defenders. This is particularly a situation that we are sustaining with the women's movements and the feminist movements. And just as a final note, we are 1 month to the 6th consultation, and we still need to create more appetite in the South especially in this context of lockdown, as Ana Maria was saying yesterday in the regional discussion, how, you know, also you can echo civil society call for a better and meaningful participation. If going to Geneva is costly, and going to Geneva to attend the meetings and convince leaders that this is an important situation, can you imagine in the situation of COVID? The reduction of our participation is obvious, and it was us, the movements, that have really been at the backstage of having today a better, not the best draft. So I really want to use my last minutes to really call you to participate, not just as observers, but really as protectors of human rights, as leaders in an instrument that can really make history in this building back better, and really ending impunity, creating more opportunities for justice and for remedy for victims and for communities. So thank you very
much, Alejandra. And seeing that we had a couple of questions coming in here rightly at the end, I see that time is now exactly up for the seminar, so I can understand that. And thank you for the panel, and thank you to everyone who needs to leave right now. That's understandable. But I will allow 5 more minutes just for Ana Maria, that took upon herself to answer these 2 questions that came in, just so you know, so that we'll have 5 minutes to sum up. But to everyone checking out now, and to the panelists, I want to extend very much thank you. Thank you for answering to our questions.
Yeah, thank you very much. Maybe provocative answers that can be discussed in another space. Jasmine, the idea of speaking about the need of a fair play field and legal security is exactly what the point I wanted to make, and I think this is very useful with companies. My task is not to defend the interests of companies, but I think for those who want to engage on it, this is one, also to explain that this treaty shall not be negative for all companies. Of course, many of them do not have profit from human rights abuses, and for them it would be very good to have the others who get profit from human rights abuses under control. And then on the ISDS, this was a huge topic on the beginning. Many organizations were even asking that the treaty finishes the ISDS, what is not possible, of course, by obvious reasons. One solution we were thinking about is that maybe the treaty could include a clause saying, for cases of human rights abuses, the arbitration mechanisms would not be applicable, and they should go to the tribunals of the states that are deciding cases of human rights. It might be a point to discuss. Maybe somebody who has more expertise on investment law can contradict my proposal, but I think that would really defend the idea that human rights decisions cannot be privatized by private judges, right? To say in a very sarcastic way.
Okay, thank you very much, and thank you to everyone for being here and for paying attention. And I hope that you have brought some of the things with you. Do we have any final note? Is maybe on the investment part, since we allowed for 5 minutes, we do have 2 more.
Should I come in on that point?
Yeah, please do.
Yeah, because I mean, I've pondered the question of how to deal with human rights claims before investment tribunals for quite some time, and I mean the problem is basically that investment agreements determine the jurisdiction of an investment tribunal, and they're usually quite silent on human rights questions. Mm-hmm. And so we have that dilemma. Also, arbitrators would probably say, well, we're not qualified to look at human rights questions because we're predominantly commercial lawyers or former commercial judges. Although that's a bit of a get out, because there are quite a lot of public lawyers who sit on arbitral tribunals and are perfectly capable of understanding human rights claims. I think the bigger problem is that investment agreements aren't about balancing of rights and responsibilities. They're about guaranteeing rights on an outdated idea that the foreign investor is at a disadvantage in the host country, which may be true of a small business that's investing in a host country, but not a big multinational. And that's why, in the end, what we do end up with is activist lawyers and activist human rights entrepreneurs actually developing new forms of claim, usually before the courts of the home country. And I've given 2 examples in my background of the Vedanta case and the Nevsun Resources case in Canada and the UK, respectively. So there is some merit in saying that if there's a human rights claim, it should go somewhere. But one of the things that is glaringly missing from ever since the zero draft is a proper claims mechanism that could work for claimants from weak governance zones in particular. Because if you're a claimant in a host country that has a functioning legal system, you've already got some sort of remedies. If you're lucky enough to have some activist lawyers who can take your claim to a home country, you've got some sort of redress. But what about the situation where, excuse me, when nothing's going on the ground, there's no legal order? Where do you go? And I mean, victims of human rights violations go to human rights courts. So why doesn't this treaty have some kind of binding human rights claims review process for those exceptional cases?
Thank you very much all for availing your time, and thank you to all attendees who tuned in. And yes, you do have also my email, and if you want to continue discussing, you've seen the hashtags. So please go in there and see what's been written by the Feminists for the Binding Treaty, by the Treaty Alliance, by the Global Campaign, and also by SOAS scholars. There's been a lot written. So stay tuned, and we'll keep discussing, and we all look forward to the next session coming October. So this will be it, and thank you very much, everyone.
Thank you very much.
Thank you, Peter.
Thank you.
And
we got each other.
Thank you. Bye for now.